What to expect from an investigation? Conducting an internal investigation into alleged employee misconduct requires skill and tact. Those carrying it out must balance thoroughness with fair treatment towards those under investigation. Before holding a disciplinary hearing, it is crucial that employers have sound evidence on which to base their decisions. Failing to conduct a full investigation, in all but the most exceptional of circumstances, may render a dismissal unfair and result in costly consequences in terms of tribunal awards, staff morale, and stakeholder confidence. The purpose of investigations is to establish all the facts of a case as far as possible in the circumstances for it to be decided if there are sufficient grounds to call a disciplinary hearing. Lack of proper investigations can make a dismissal unfair. It can have very serious implications in discrimination and bullying tribunal cases. Principles of natural justice. Inform employees about the allegations against them ahead of time. They should be given a chance to reply to the allegations in a meeting. Decision-makers should be fair and act in good faith. Employees should have the right to appeal to a higher authority when available within a company. People business skills in handling investigations. These are the skills that people business demonstrate in handling investigations. Knowledge of the legal aspects of discipline and grievance and the conflicting rights and responsibilities of all those involved. Experience in handling general employee complaints and grievances. Familiarity and access to the organization's structure, policies, practices, and management procedures. Impartial, independent, honest, professional, sensitive, and direct. A neutral party who is neither a friend nor colleague to those that participate in the investigation. Had no personal involvement with individuals concerned, nor events being investigated. Will not be involved in deciding the outcome of any subsequent disciplinary hearing. Have had suitable training and experience. All our investigators comply with the following principles. They are thorough, objective, don't make any assumptions, tactful, firm, always maintain confidentiality, and keep records. The investigation report. Once the investigator believes they have established the facts of the matter as far as is reasonably possible and appropriate, they will produce an investigation report that explains their findings. Our investigation report will cover all the facts that were or were not established, and whether there were any mitigating circumstances that also require consideration. To exclude any information may leave an investigation open to accusations of bias and filtering evidence to suit the commissioning manager or client's findings. A consistent structure to the investigation report ensures that all issues raised and agreed with the commissioning manager in the terms of reference are covered, and all of the investigation's findings are included. The investigation report will be written in an objective style. Avoid nicknames and jargon. Use the same form of address for all people referenced. Use appropriate language. Stick to the facts of the matter. Be concise. Explain any acronyms used. Include all evidence that was collected. It will also contain the investigator's own conclusions. Request to make a recommendation. It is common for an investigator to be asked to make a recommendation. Their recommendations will be restricted to only suggesting whether any further action may be necessary or beneficial. An investigator's recommendation will detail whether formal action, informal action, or no further action is necessary. It will not suggest a possible sanction or prejudge what the outcome to a grievance or disciplinary hearing will be. Formal action an investigator could recommend will usually be to initiate a disciplinary hearing, changes to an organization's policy or procedure, further investigation into other matters uncovered. Informal action an investigator could recommend will usually be training, coaching, counselling or mediation for parties involved, and notification that further similar action may result in disciplinary action. No further action recommendation. Although an investigator may find there is no further action necessary, they may recommend that counselling, mediation, or another form of support may be beneficial to the parties involved and the organisation. Once an investigator completes their investigation and submits their report, they will usually not be involved in any further action. It will be the decision-maker commissioning manager and not the investigator who makes the final decision as to whether or not a disciplinary hearing will be held. If their decision differs from the investigator's recommendation, the reasons for this should be written down and included as an addendum to the report.